This is episode number 31 of the Inland Empire Workers' Compensation Lawyer live stream podcast. George and I have put together 30 episodes so far. This is the 31st episode. We discuss important issues that you might face if you're injured at work in California. This episode number 31, is about when the employer wants you back to work. So if you've been injured at work and you've gone to your employer, you've reported your injury, or maybe you haven't, but your employer wants you back, what do you do? What are your options? You need to check out this short discussion that George and I have put together. It's going to give you some insight into the situation and predicament that you're facing. But remember, it's not legal advice. If you've been injured at work, you need legal advice, dial the injury helpline. That's 844-984-8414. With that said, George, what can an employee do if their employer wants them to get back to work?
That's a good question, Alex, and well said. Everything you said before that is true. And one thing that I want to make clear that you already said, but I do want our viewers to be very, very aware of, is that every situation is different, especially with the topic that we have today, because the employer might be a huge multinational corporation that you work for. You know, you might work at a warehouse or something for, let's say, Amazon. They're huge. Or your employer could be a small mom and pop shop. So two very different situations. What if both employers are telling you, hey, I want you to get back to work? What if your manager at Amazon warehouse is saying, hey, what are they saying? What's your doctor saying? Have they told you can get back to work yet? And they're really pressuring you. Or what if you work for a small restaurant, maybe a chain of 5 restaurants that they own, but they're still small, and your employer is directly coming to you and saying, we need you back at work. Has your doctor released you? Whatever it is, we need you back at work. Still being pressured from an employer. Two very different types of employers. So we're going to talk about that type of situation.
All right. So you've been injured at work. You've gone to your employer. The employer is saying, hey, come on back. Get those work restrictions lifted.
Yeah.
We need you back right now. Well, they can't discriminate against you for filing a workers' compensation claim or having a disability. So
right.
That's a fine line your employer is walking. So if you do have an employer pressuring you, you definitely need to call an attorney and ask about your legal rights. What we discuss here, it's just general in nature only. So, George, what can be the consequences? What do you do?
Well, I don't really care what the employer is saying, is the truth. Employer has no bearing on your medical treatment or when you can get back to work. That has to be decided by yourself along with your doctor, right? The primary treating physician or the QME. But the employer shouldn't have any say on whether you should be back at work. Now, the employer will receive the list of restrictions, and they might be able to offer you modified duty. That's a different situation that we've already discussed in one of our videos, correct, Alex? Right. But as far as them telling you, hey, I need you back at work, that doesn't matter. You shouldn't. Once again, if you're getting pressure from your employer, please give us a call. We're always here to help and answer any questions, but that's something that you should not be dealing with. Now, a lot of employers will go directly to the employee and say, listen, when you go to your next medical appointment, you need to tell your doctor that you're feeling better and that you can go back to work without any restrictions. Now, that's going to hurt you in the long run, of course, for different reasons that are obvious. And if you have any questions, let us know. Right. But that's going to hurt yourself, your health, and your case in the long run. You don't want to lie to a doctor and say, oh, doctor, I'm fine, I can go back to work, when you're really not. And number two, the employer has no right to make you say that. And my advice would be never to just do what your employer says and lie to your doctor just so you can go back to work. Okay?
And you might feel inclined to do that for your employer because it's your livelihood. But I've had clients do that, and then 6 months later, they're out of a job.
Right.
And they've told their doctors that they're fine. And there's a big issue because the discrepancy in the medical records.
Right.
And you need to be watching out for yourself. So if you have an employer pressuring you, not only could it be a violation of your disability rights under the Fair Employment Housing Act, but it could also be super detrimental to your workers' compensation claim benefits.
Yeah. And also you might qualify for something else called a 132A. Won't get into that right now, but it's also when they treat you differently because of your injuries at work. So that's something that we've already discussed. If you guys have more interest in that, please let us know. Discrimination claim to go along with your workers' compensation claim.
We've discussed that in a prior video. We'll throw the link up there. So if you're watching this video, you want to take a look at that, you think your employer might be discriminating against you, it's a good resource.
Right. Also, Alex, there's two types of situations. One where they ask you to lie once the claim is open and everything's going fine. But I have had clients where They come to me after a year of receiving medical treatment under the table, and now they want to open up a claim. But they already have a year's worth of medical reports stating that they got hurt in their backyard, or they got hurt playing a certain sport, because that's what their employer told them to say to their doctors. So what happens in that type of situation, Alex?
Oh, things could be bad. I mean, if you've established an entire year of medical treatment, if you've gone to your own primary doctor on your own health insurance, and you've lied and you've said that you got hurt playing baseball or something, that could come back and bite you. You might never be able to make a claim because your employer might say that this person is just a liar.
Right.
I mean, that could become insurance fraud. So you got to be very careful if you're out there and you've been treating on your own. Now, if your employer has been sending you to the clinic for cash and you haven't lied or said anything to a doctor about the history of your injury and they're just treating you, well, they're probably trying to avoid workers' comp claims,
right,
which increases their insurance premiums. So it's time to discuss with an attorney for sure, especially if you have permanent injuries.
Oh, of course. And those are two different situations, just to be clear. The first situation we discussed at the beginning of this video is you're going to get medical treatment. Your workers' comp claim is open. It's already being handled. And the employer wants you to get back to work because you're still getting ongoing treatment. And they ask you to lie so you can get some restrictions taken off. Or they ask you to tell your doctor, please take off my restrictions. That's one situation. What we just discussed is when you actually get injured at work and your employer knows about it and they specifically tell you, go get treatment at this facility or find your own medical treatment, but tell them that you are hurt somewhere else, anywhere else except work. Okay, two very different situations, but they both come up very often. Yeah. So we wanted to, they're both bad, and both you should definitely not comply with your employer's request. You should always tell the truth and get your claim started the right way at the right time, which is the beginning, by giving us a call.
Definitely. Yeah, that's a good point, George. You know, when the employer is sending you to medical care under the table, like if you go to the industrial clinic and then you look at the paperwork and there's no insurance carrier listed on that paperwork and it just says cash or something, that's a big red flag. Now, your employer might be saying, hey, well, I'll pay you. Don't worry. You're off for a little while. I'll pay you. No big deal. Yeah. A week, 2 weeks, 3 weeks, but 4 weeks, 5 weeks, maybe the payments are going to stop. Once your employer finds out that you have a very serious injury, now you're a whole month behind. You're not getting paid. Your claim doesn't look appropriate. It's going to take some time to work that out. If you're in that situation, you need to dial the injury helpline, 844-984-8414, and have a free and confidential case evaluation with either George or myself.
Right. Now I'm going to discuss just a little sidebar here, Alex. One thing that happens a lot, and it shouldn't, is that you don't feel well, but your primary treating physician, may be designated by your employer, is saying that you have reached permanent and stationary status, which means that you can go back to work. And maybe there might even be saying that you can go back full duty, but you still don't feel well.
Maybe on the first visit.
It happens all the time. What do you do? Once again, we discussed this in one of our prior videos. Please check those out. You have a right to go to a panel qualified medical examiner. However, prior to doing that, you might be in a tough situation, because if the doctor's saying that you can go back to work and now you're refusing to go back to work, well, the employer has different options that might not be favorable to you, okay? So you don't want to go against your PTP and just decide on your own, hey, I can't work. What should you do? This is advice I give some clients, and once again, this is not legal advice. I'd have to look at your situation, assess that, and tell you what your best option is. But what I tell them, Alex, and let me know if you agree with me, is if the doctor's saying go back to work, go back to work. But if you're at work and you're getting pain in that same body part or now in a new body part, report it immediately and say, please, I'm at work like I was supposed to, but I cannot perform this duty. I need to see a doctor immediately. And when they send you back to work without you wanting to go back to work, if you didn't before, that's the time to call an attorney immediately, because we will switch you doctors. We will make sure that you can go back to work, or if you can't, that you're taken off of work. So please call us. We can help you out with that type of situation. But if you are being told by your doctor you have to go back to work, my advice is comply with what your doctor's saying. If your job is offering you employment, and once you're at work, if you can't perform those duties, let your supervisor know, let your employer know, and tell them that once again you need to be resent to the doctor because you can't perform your duties.
Yeah, those are the hard situations where you just feel you're not being treated right by the clinic. They're not giving you the work restrictions that you think that you need. So you go back to the employer, and the employer says, "Oh, we got your old job back for you. You don't have to lift more than 100 pounds. You have to lift only 95 pounds." And that's pretty heavy if you got a hurt back right there, right? So they're not treating you right. You need to go back to the doctor. I think it's a good point. If you don't, George, you hit the nail on the head. If you don't show back up to work, they're going to then try to terminate you for cause.
Right.
And then when you do get a legitimate doctor to look at your injuries, they're going to try to deny you your temporary disability payments because they're going to say, well, we could have accommodated the injured worker, but for the fact that they got themselves terminated for no call, no show.
Right.
And then this is just it's this fighting that affects your life so much.
Yeah.
So go to work, report the pain again, get back to the clinic again, get more restrictions, call a lawyer immediately for that legal advice that you need, because you might need to go to the emergency room to get an off work note.
Right.
You might have to go to your primary care physician. You might have to go to an urgent care. There might be other things that you need to do in the immediate to save your position at your job, which is ultimately going to give you more bargaining power, even if you ultimately decide that you need to leave that job because you can't do a permanent job there anymore, or you just want to move on.
Yeah, and so many of these small decisions that you make without an attorney could affect your claim in the long run, could switch your claim up and just get you no money, right? So don't make these decisions without speaking to your attorney, which should be us. Give us a call at
844-984-8414 or visit our website, www.workerscomplawyerinc.com.